Right, now what are we here for?
We're here for the motion for leave to subpoena or notice for deposition the other two witnesses on our witness list. They are the subject of protective orders. And I know the court, we have limited time today, so I want to just cut to the chase, if I may. Just suppose has written a check to me, and today I assign that over to counsel here. I cannot come back next week and assign that check over to counsel simply because I no longer have a check to assign. The Chase's lawyer, the one that's subject to disqualification, we believe her involvement in an attempt to do exactly that is what puts her qualification at issue. The lawyer's name is. We believe that her testimony is presumptively necessary to support Chase's claim because Chase's claim at this time depends entirely on a December 2012 assignment of mortgage from MERS to Chase. Drafted a complaint in October 2012 stating that an assignment from MERS to Chase not only existed but was attached to that complaint. That's in October 2012. That statement was verified by Chase Vice President also in October 2012. For reasons unknown, prepared another assignment from MERS to Chase that was executed in December 2012 by another Chase employee posing as a MERS officer. Recorded this new assignment the following month in January, just days before filing the complaint that initiated this case. And that complaint again verified the existence of an earlier assignment. Strangely enough, she failed to attach either assignment from MERS to Chase to that complaint. And none of those facts are disputed at this point. All of those facts are of record. So we believe Chase must call testify to the propriety of the December assignment because their entire case at this point relies on it. No other witness can explain her actions to this court, but we believe the court needs to hear that explanation to determine whether she's necessary. Mind you, Your Honor, we're not arguing that she is a necessary witness today. That's something that the motion to disqualify counsel, the evidentiary hearing on that motion will determine. We are arguing, however, based on the facts I've just outlined, that she is a material witness, as are these other two witnesses, because, again, Chase's claim at this point relies entirely on an assignment of mortgage that actions are put into question. Now, there are, as I mentioned, a couple of other witnesses that we need to depose. It is the Chase Vice President who verified the attachment of the assignment in October of 2012. We believe the court needs to know whether she will testify to that fact at trial, or rather admit to perjury in her verification. The court needs to know that to determine whether she is in fact a necessary witness. We've already handled that matter is, again, the Chase employee who executed the December assignment on behalf of MERS. That assignment, mind you, stated that MERS, and I quote from the assignment, does hereby assign, transfer, and set over onto Chase subject mortgage. That's in direct contradiction to verification just 6 weeks earlier that the mortgage had already been assigned, transferred, and set over to Chase. And so we believe the court needs to know how he was able to make that assignment, or whether, in fact, he was unable to make the assignment. The court needs to know that to determine whether, again, this is a necessary witness in this case. I would just point out finally here that by drafting and filing the initial complaint with the Chase Vice President's verification, essentially attested to the existence of an earlier assignment. Now, we all understand that an attorney representing the client doesn't make factual statements on any personal knowledge. She's simply representing the client. But again, a quick aside, if Little Johnny throws a baseball bat through a neighbor's window and a lawyer representing that neighbor writes a complaint saying Johnny threw the ball through the window, that's the client's statement. But if the attorney attaches the ball with shards of glass to the complaint and attests to that in the complaint, well, that's some personal knowledge involved there, that the ball is attached to the complaint. And that's essentially what we have in this case. And we would suggest that herself attested to the attachment of an October 2012 assignment on the initial complaint. In contrast, by drafting, preparing, and recording the December assignment, she essentially attested to the non-existence of that very earlier assignment. And so I think I'm sorry?
Who wrote that up?
My handwriting. I think the court needs to hear her explanation of those contradictions. There's one other minor contradiction. If you look at the assignment on the top left-hand corner of the assignment, the statute requires that the executor, which would be MERS in that case, list their name and address. And as you see, it's name and address. And so they are essentially representing both MERS and Chase in that transaction. I think there needs to be an explanation of all of those facts. And the court needs to hear that explanation and can only hear that explanation from Ms. to determine whether she is a necessary witness in this case.